So the best interest of the child, you've heard it many times today. That's the principle more so than any other that guides our work as lawyers and judges in child dependency proceedings. It permeates all of the law and policy and practice. Again, how many times have you heard it said today? There'll be more. It's really understood and applied as an intensive fact-based inquiry into the circumstances surrounding an individual child's safety, permanency, and well-being. And in a best practice scenario, it reflects the child's perspective as we enter his or her world. The early part of my career, I naively believed that this best interest of the child standard was an objective standard, and even, dare I say, an apolitical one. It struck me as kind of an absolute truth, right? A universal truth that would guide my steps and decisions in the right direction for children. That it would transcend somehow the resource constraints of our system and the limits of our personal philosophies. And I hear my students wonder aloud about this now. Surely children's interests are so pure and so obvious that we should all be in agreement about what is best for them. After all, we all know children. Many of us are raising children, and we've definitely all been children. So surely that means we must be experts. It turns out that is a dangerous and unfortunate casual assumption. It was one that I made based on a subconscious and maybe even offhand reflection on my own childhood. You see, I was adopted as an infant, which means that the law and two loving and overprotective parents and a fiercely loyal sister made me a part of a perfectly imperfect family. That family was based on the best interest of the child standard, the best interest of me. And yet I've always been curious about how is it that the law knew what was best for me. So I've kind of been on this lifelong professional journey of fascination with the power of the law and the way that it can construct and deconstruct families. And as we move forward into all of this, there's a reflection on that exact standard. And on that journey, I've learned that this best interest of the child standard is probably the most subjective of all standards. I've wondered even if it's a meaningful concept at all, if it's just a convenient construct that we've created to help us justify our views, help us be decisive when we need to, help us assuage our fears and anxiety about risk within family that we can't manage, and help us entitle us really to claim a superior position about who gets to be part of a family and on what terms. You see, that's what is at stake in this work that we all do. And I don't have to tell you, as lawyers we all know, that the law is not the place where you find answers to these complex problems, but really where you start to find the questions that you seek answers to. And so I am not just a lawyer, I'm a meddler. I'm a gadfly. I've made an entire career out of being an opinionated, sometimes sneaky know-it-all who I've been since age 7. Except that now I like to think of myself as resourceful and strategic, right? And after nearly 2 decades specializing in this field, I think I know a little something, and I'm more eager than ever to help find the solutions. So I'm here to invite you, to encourage you to be agitators of the system, of the status quo, to be disruptors in our current language, to concern yourself with solving the resistant and persistent problems of the child welfare system by being an engaged professional. In my view, we can only hope to change the outcomes that we seek for individual children and families by changing the context in which those outcomes are determined. We must meddle in the system design and operation with all of our knowledge and experience, all of our good intentions, until we stumble across a solution. And in fact, I think that as members of the legal profession, we are duty-bound to do so. Lawyers, all of us, right, have sworn an oath. We swear an oath to exercise competency and diligence and loyalty in client representation, to be fair and courteous to opposing counsel, to be candid, to be courteous and respectful to the courts. We also swear to be of service to the law and to the legal profession. In fact, ethical rules instruct all of us that we have a special responsibility for the quality of justice. And I believe that justice is found not just in the courtrooms in which many of us show up every day, but also in agency boardrooms and in the halls of state capitals. And so what would be your role there? To be an expert informant, right? To offer technical advice and information to overcome knowledge gaps. to be an honest broker, engaging in the policymaking process as an objective expert and fair dealer of competing interests, to be a capacity builder, lending your support to advocates and other third parties who themselves will directly influence the process, mostly to meddle, right? To challenge and refute the casual assumptions that are held about what is best for the children and families involved in this system. In my experience, policymakers, lawmakers, just like the rest of us, only have casual assumptions on which to base their decisions. It's not that they don't care, but that they don't know. They really only have maybe some limited personal exposure to this work, mostly what is told to them by people they deem credible. And so I'm asking you to be those people they deem credible, to step forward and lean into this process, to engage yourself in the decisions that are made about the system design and processes. Consider for a minute these casual assumptions that are often held about the child welfare and foster care system. These are things you've heard before, and sentiments I've heard recently from elected officials. That, for example, foster parents and relatives are in it only for the money, right? That this child welfare system is full of incompetent and uncaring baby stealers who take too many children, or incompetent and uncaring bureaucrats who don't take enough children. That the children themselves always just want to go home to their abusive parents, so there's really no reason to involve them in the adult decisions that are going to be made about the future, their lives in the future, their future lives. And that having judges and case managers and lawyers for everybody and CASA all involved just overcomplicates things, so we need to figure out who needs to go. Right? Now, consider for a minute the state and local policies and processes with which you may be familiar that reflect these beliefs. The way that we treat each other as professionals, the way that we judge the actions and intentions of caregivers, the way that we regard children. Because after all, public policy is really just a set of value priorities and the casual assumptions about how to realize them. And the law is just an enshrinement of public policy. We can and must do better than casual assumptions to guide the policy about how to ensure the safety, permanency, and well-being of children. We have to insist on research and evidence and data as context to discipline the thinking, the way that lawmakers think, believe, and act. We have to provide context, the greatest context about the families and the work and how we experience it. We have to lift up the experiences of our clients to bring human dimension to an understanding of the problem and development of solutions. We have to insist that policymakers sit with the complexity of this and resist the allure of elusive silver bullets. And in doing so, we will advance a higher quality of justice for vulnerable families. So as we continue this imagination journey of today, imagine yourself as a lawmaker. Right? The door of your office is a turnstile for a parade of lobbyists. You've entertained your 14th request today for more funding. You're responsible for voting on hundreds, maybe thousands of bills, and you race from that last committee meeting to your son's Boy Scout ceremony, always mindful of neglected obligations to family and work. Your law firm just wants you to come back and work for your paying clients again. What are you basing your decisions on? Same thing we all would, casual assumptions, right? And those casual assumptions, those ones that are rooted in and derived from an incomplete understanding, often give rise to, at worst, biases based on race and gender and economics, right? They most assuredly result in a distorted perception of the problem and obscure strategies and misguided policy solutions. And what that means for all of us is that nothing improves. So now consider a children's lobby. You enter the scene as part-time meddlers. And how does that look any different? Well, now you're there to dispel myths by sharing research and data and your own experience about how diverse the children are in our system, which is why we need diverse families to care for them. You are there to deepen understanding of children's developmental needs and the profound impact of trauma so that lawmakers feel confident about their vote for more resources to support a full continuum of care and services, and a stable and sophisticated workforce skilled in knitting back together fragile families. You're there to insist that the law matters, that there are rights rooted in the Constitution and in statutes that should be the start and end of these conversations. even if they make the conversations more complicated and less efficient. You can restore the nobility of the social work profession by lifting up accounts of case managers who've been creative and courageous and gone above and beyond. You can inspire compassion by telling the stories of parents who've overcome demons of mental illness and drug addiction. And you can rebuild public confidence in this system by reclaiming the narrative about what this system does and why. And then you go back to your courtrooms and your law offices, and one day, things are better. Burdens are eased. Resources and services that you didn't have in your community before now exist, or access at least has been broadened, and your jurisdiction becomes a bright spot to inspire other jurisdictions. Hostility between professionals who used to battle at every turn has lightened, lessened. Children and families feel heard, respected, and even helped. Imagine. And one day we won't have to use our imagination because we'll look around and children will be safe in families and supported by communities. When we are confronted by these wicked problems, the kind that we see in the child welfare system, those problems that defy simple definition and straightforward solutions, we often feel overwhelmed by the need to solve them all at once. After all, the challenges of the child welfare system are easy to identify and many to list, right? The stakes are high, the needs are urgent, and yet, as it's said, you often have to eat an elephant one bite at a time. And that sometimes you have to build that plane while you fly it, and all those maxims apply. So instead, pause. Think about what it is that you spend your time reflecting on. Why can't we do this better, whatever the this is? What's causing you to lose sleep? What are those moments of greatest impatience or growing intolerance? What is it that gets your blood pumping and your brain firing and your muscles engaged? And let that be your place to start. Because small changes can make massive impact. And we need as many people working on solving these problems as the problems themselves are big. Thank you.